and any information brought before this committee should be based on facts. In terms of the protocol of this committee, please minimize the usage of mobile phones and all mobile phones be on silent mode while the meeting is in progress. I wish to also remind the honourable members and our guests that all questions to be asked are to be directed to the chair. To the public tuning in, today the committee will be hearing a submission from Pacific Polytech on the Education Bill, Bill number 34 of 2025. Briefly, the Education Act of 1966 is the foundational law of pre-tertiary education in Fiji, and since its declaration in 1966, the Act has only been amended 7 times. Given that the Act had not undergone a comprehensive review since its inception, it became imperative that such legislation be reviewed to up-to-date to modern standards and best practices, and to also address the developing issues and concerns within the education system in Fiji. The Education Bill therefore seeks to repeal and replace the Education Act of 1966. It also seeks to repeal the Higher Education Act of 2008 and the Fiji Teachers Registration Act of 2008. To bring together higher education, teacher registration matters under a single education umbrella and one legislation. To the public who are listening in, ladies and gentlemen, and to our submittees, I would like to take this time to introduce the members of the Standing Committee of Justice, Law and Human Rights. Furthest to my right, the Assistant Minister for Itoke Affairs, the Honourable Ratskeli Tuelewu, a member of this committee. Next, seated to him, former Minister and currently a member of the Opposition, the Honourable Chone Usmate. Next to him, the Assistant Minister for Justice, Honourable Ratu Chusaya Nyundamu. And next to him, former Minister and also a member of the Opposition, Honourable Fayaz Koya. And myself as Chairman, Ratu Rakuita Bakalalambure. Honourable members and the public, ladies and gentlemen, I would also take this time to introduce our submittees from Pacific Polytech joining us this morning. We have with us this morning is Dr. Ganesh Chand, who is the chairperson. Welcome, sir. Mr. Michaeli Naikaukawesi, Mbulubinaka. Dr. Salesh Kumar, Senior Manager, Bula, sir. And Mr. Iso Tamani, who is from the Corporate Office. Honourable members and ladies and gentlemen who are tuning in this morning, let's take this time to welcome our team from the Pacific Polytech who are here to give submissions on the Education Bill. Without further ado, honourable members, I will now give the floor to the team from Pacific Polytech, probably Dr. Ganesh Chan, to take us through their submissions for the Education Bill. You have the floor, sir.
Thank you, sir, and thank you, members, for giving us the time to give our views on the Education Bill. I know you have been very busy traveling throughout, hearing submissions on this and many other bills before you. What we thought is, instead of restricting our submission to matters which only concern Pacific Polytech, we will give a submission on the entire bill itself. We thought that might be more meaningful. So you might have seen 2 projections. The first one was only what concerned the specifics relating to TVET and Pacific Polytech. This is the bill that you are deliberating. We thought that we'll go through each section which we wanted to bring to your attention for consideration. We have highlighted those sections, and there are comments on each of those highlighted ones. If you could, no, comments would be, yes. If you go to the top and here, edit comments, and you'll be able to see all the comments. No, edit, you'll be able to see the comments. We have commented on each section that we thought we will bring to your attention for easier reference. It's on the same document. Um, huh? View comments? No, not that. No, not that. It's, yes, that one. I think that's the one projected. We start with the long title, further down, yeah. There. So there is a comment on that. Normally you click on edit, then it will show all the comments on the side. No. Comment? Yeah. Edit, comment. Just press, let's see. View comments. Yes, I think you can see them there on the side. Yeah? Can you? Yeah? You might have to expand that. That is, the side, yeah. Yeah. Give me that laptop. Give me that laptop. Yeah, it's working. Yeah. Let's see. Yeah, no, it's the same one, but that thing on the side you have to expand.
Enlarge it.
Enlarge it, yeah. Oh, that on the right hand side or left hand side, depending. But I can go through it.
Yes,
yeah?
I think so. That
We'll
would
leave that for you.
Yeah, that would suffice if you just go through it.
Yeah, okay. Thank you. Yeah. So the first point we want to make is that in the long title, there is reference to technical and vocational education and training. Nowhere in the Act bill it is defined. What do we mean by that? I think it's critical that we define it. Otherwise, it will remain vague. So that's one part. We are going to talk about the Higher Education Commission. As you had mentioned, Chair, that the bill aims to repeal the Higher Education Act, and it has incorporated some provisions on Higher Education Act in the current bill. We have a submission to make on that. In terms of definitions, boarding school. The boarding school is defined as schools which are either government schools or government aided, which provide boarding and accommodation. There is a matter on definitions itself. The bill uses the term private, government, and government aided. Now, private schools are not defined anywhere. Is a private school government aided school? What's the distinction? Can private schools be entitled to government funding? Because later on there is provision for tuition-free education in primary schools. So if there is a private primary school, would it be entitled to government assistance? So there is a lack of clarity there. We thought that it would be better to define boarding school as all schools which have boarding facilities, rather than restrict it to government and government aided. There are 3 universities which are defined in the definition section, Fiji National University and later on University of the South Pacific and University of Fiji. We are saying these definitions are redundant because there is no mention of these in the text, the body. So why define? We have three definitions which are redundant. So we are saying that that should be deleted. Maybe it's from the earlier version where references were made. Then in terms of government-aided school, the second part is maintained out of public funds. So the question that we are posing is, does it mean fully or partially? What about a situation where government funds only a small part of the maintenance of the school? For example, a school receives, say, 10 computers for the lab. Is it government aided? Or does government aided mean continuous year in, year out, annual support? So maintained out of public funds is a bit unclear on this. Also, government-aided school, it says controlled by the ministry. So it really technically would rule out the most of the schools in Fiji because they are not controlled by the ministry, they are controlled by committees. For example, take any school, there are only a handful of government-controlled schools. So we thought that we will bring it to your attention for your deliberation.
Dr. Ganesh, just a question. Is it your submission that Fiji National University and the USP, these to be removed from the definition, correct?
Yes, sir.
Because they are not highlighted in the bill. Is that correct?
Yes, very good.
Okay, thank you, sir.
Yeah, thank you. Homeschool, an arrangement to provide an education. It's a bit quite vague. There is, especially when you relate it to the sections on compulsory enrollment and attendance. So how would the homeschool be regulated? Homeschool normally means that a parent decides to educate the child outside the school system at his home or at a particular venue, at an approved location. Now, minister, the definition is the Minister for Education. Our main submission is that perhaps we should distinguish between education relating to ECE, primary and secondary, from post-secondary or what are called higher education institutions. And that will come towards the end of our submission. Now, secondary school itself, what does it mean? It means a school that provides secondary education. So there is the secular referencing. What is secondary education? Where does it begin? Where does it end? We understand that class 1 to 8 is primary, and then from Form 3 to Form 7 is secondary. Is that what we are encouraging here? So we think that there has to be a clearer definition of secondary education and likewise for primary education. It will have a bearing when we talk about TVET in schools, because secondary education is education, not necessarily training for vocational purposes. I have already mentioned University of Fiji and USP, so they are redundant. meaning of school, uh, clause 3, subclause 2, part C, it's an institution in the following list is not a school, despite subsection 1. An institution that has been exempted from subsection 1 by the minister. The question we are posing is that whether it should be individual institutions which are exempted or a category of institutions. There is a subtle difference in that. What is the power of the minister? To exempt individual institutions or a category of institutions as a general category? We are proposing that it should be a general category, because otherwise you will have one institution which is not exempted, the other is exempted, and there could be arbitrary decision making. We have talked about the lack of clarity on technical and vocational education, and of course there is a provision on continuing with higher education, section 5, section 5, yeah. So we'll talk about those in a while. 8, free education. A primary education is provided free of charge in a government school and government aided school. For secondary, where state has available resources, and tertiary, where higher education, where state has reasonable resources. Now, the broader submission that we are making is that this is really a policy matter for government. The question that we are posing is, should it be in a law? We know that the Constitution says education is a basic right, but should it become a law? I leave that to the committee to deliberate. My own view is that given that it's a government's policy matter, we don't want a situation where a government which doesn't agree with this provision comes to amend the act later on. So more generally, our submission is that the law must only be an enabler rather than contain specifics. Because if you contain specifics, then a new government or any government in future would want to amend it. And there will be too many amendments. I do note that the bill requires review every 5 years, but still, as you all know, it may not be possible given the legislative agenda of any government. I agree generally that there should be free education from primary to tertiary. That's our belief. But then even in tertiary higher education, as subsection 3 says, our question is there any limit? Would it go only up to a certificate or a diploma or a degree or postgraduate qualification or a PhD? Where would you end? So that's a question that needs to be defined. At the present moment, there are significant difficulties. A student which gets, say, TELS scholarship for certificate 3 study cannot get any scholarship for diploma. That's it. While a student can enroll for a 5-year degree, say in medicine, or 4-year degree in law. So one person can get 4 years of state-funded education, the other 1 year in certificate 3. So it's a problem that we need to deal with.
The issues that you're raising, Dr. Ganesh, would those definitions better be left to the regulations even if we keep it like this here? Is that what you're saying, or is you saying something else? I don't... Those
yes,
detailed stuff.
Chairman, that's one way of dealing with it. But what we are suggesting is that any policy matter should be left out of the legislation. legislation should be only the framework rather than a policy statement. And it goes right through the bill. There are a lot of policy matters which are there, and very good ones, but they are policy matters. They are not.
No? Because the issues that is raised here, this is just repeating what's in the Constitution. It says provide free education up to the extent that government can finance it.
Yes, a government may come, Chairman, and say, look, we can't finance it, not even primary. How do you, what are the indicators of whether a government can finance or not finance? It's very difficult to specify. A government may say, we have got a lot of debt, and therefore we won't finance even primary.
Probably what Honorable Sumati you're trying to say is an exact quote from the Constitution.
No.
Saying some things along the lines of what is said in the Constitution.
The Constitution says it's a basic right. It's a basic right. It doesn't specify on yes, how you fund it. And that should be a policy matter.
Just, if I may, Chair, Dr. Ganesh, the clause in there basically says that the state must show that the resources are not available. If the state claims that there are no resources, it must, it doesn't say may, it says must show that the resources are not available. It's a clause that, it's a bit of a, backstop at the end of the day. But do you think that doesn't sufficiently cover it? If in terms of if a successive government came and said, look, we can't do it, no more free education, they must show that the resources are not available.
Yeah.
This would be, again, something that would be subject to the courts at the end of the day for all of that, if somebody decides to take it up.
When you look at that matter, one could justify resources are available or not available. There is no technical definition. Unless there is a technical definition of what does it mean by resources are available or not available. What does it mean, not available? There is no technical definition. One can argue, yes, resources are not available because we have to pay here, the roads and the debt. Another one can say, no, it's available. You can borrow and then fund. You see, borrowing is a resource. So it opens up questions which are difficult to address. Though I don't think many governments will say we don't have funding for education or health or roads. But I'm just saying that why should we bother our legislation with that difficulty? Let it be a policy matter. So, same thing, the entire clause 8. There is one section on subsection 5. For the avoidance of doubt, an education is provided free of charge to a student if the student is not required to pay a tuition fee. So it's only free education means tuition, but not other fees, enrollment fees and these penalties. These are a range of fees which could be charged. Later on, there is a provision that you can't do fundraising and all these kind of things. So what does free education really mean? Does it mean only tuition? What about book fees? What about school fares? And the other major one that we will be talking about is on the health of students. We are saying that a major problem is nutrition of, particularly in primary schools, of students. Who is responsible for that? Should it be funded? It's a policy matter, but should a reference be made on health and nutrition of students? In some countries, a meal, at least one meal, is mandatory as a policy matter, Japan or India or many other places. Then there is a definition of mature student. We do note with interest that a child is defined as up to 18 years, and after 18 years is mature student. Polytech and many institutions have been struggling with the definition of mature students. So this bill kind of clarifies what is meant by that. So it's good that students who have been left out will be mature students who couldn't complete would be catered for. But it also requires government to develop and implement education programs. So what does it really mean? If there's a student who was left out, say exited at Form 4, is now 25 and wants to come back in the education system, would that person be required to do the curriculum of the secondary school, or could that person do something else in the education and training area? So developing and implementing an education program is a very difficult ask of the ministry. That should be left to the providers. Then the other issue that we have, we want to bring to your attention is attendance. Regularly attend means attend each day. And there is a very onerous demand on school heads as well as the ministry, going right up to the magistrate court to get an order. Now, we are bringing it to your attention. I think attendance is good. You need students attending, especially when you are funding it. But this is something that may come and bite us later on, if it is in the law. If it is a policy, then you can deal with that. Yeah, as I said, it goes up to the magistrate for an order. Go to 11. Yeah. A person may apply to the minister for an exemption from attendance regulation and all that. So does that mean that an individual will apply or a category of students will apply? We don't know. Other minister could be overburdened with applications to exempt. It will be an administrative nightmare for the office of the minister. It says by notice in a gazette. So a gazette, it has to be gazetted that Maikaline Kewaka Vesi is exempted from this provision on attendance, and it will be gazetted. Now imagine if there are many more students like that. And the head of school will have to regularly report. Should it be on a daily basis, weekly basis? There's a lot of administrative requirements. Okay, if I may proceed, the Part 4 Education Advisory Council. I note that this is an advisory council. It advises the minister. Later on, we say that even the bill says the minister is not obliged to accept the advice. And that's where it ends. So the question is, should the minister advise the council on why he or she is not accepting the advice? Or that's it. If no reasons are given for not accepting the advice or recommendation, then the council can actually become redundant. Imagine a minister sometime in future, he doesn't agree with this advisory council and he doesn't accept any advice. The council becomes redundant. At the present time, we have got the Education Forum and many other bodies which are redundant in many situations. But before we go to that, the definitions itself need clarification, like the head of the Teachers Association, the head of the Principals Association, the head of the school management. What does that mean? Is it the president, the trustee, the secretary? Who is it? I think we need to define more clearly. One approach could be that there be a nominee from the Head Teachers Association. So the Head Teachers Association will meet and nominate one person. Likewise for all the other institutions. Then we have in that council 2 reps of higher education institutions on a rotation basis. I presume 2 years, that's the term of the council membership. Provided that one is from the private higher education institution. Now, private has a connotation of profit making. In Fiji, we don't have any such institution, higher education institution. The appropriate term should be, we suggest humbly, non-government institutions. So there is a government institution, there are non-government institutions. Government is, for example, FNU is a government institution. University of Fiji is a non-government institution. A rep of the technical and vocational education and training institutions. Now, this itself raises some questions. Could the rep be from, for example, FNU? Because FNU also is engaged in TVET. What if FNU also has a rep under subsection G? You see? So, what does it mean, a rep from the TVET institution? On I, maximum of 10 reps from various stakeholders. It says the minister may select in his own judgment. There is no selection process specified. So, one minister in future may appoint someone from a very small, say, women's rights group. Ignore the main ones. So, there should be a process specified if you are going to have it legislated. Persons with expertise in mental health, digital literacy, curriculum development, library services, all these. Again, the selection process. Who is the expert in digital literacy? How do you select that person? Should there be some achievement criteria? 10 reps of controlling authorities. But earlier we have got the School Management Association of Fiji on the council. Then there are controlling authorities of schools, again, 10 of them on the council. So it's a bit of a cumbersome council. It says minister appoints the representative, section 3, if you keep going down. Just before 15, yeah. Minister appoints the reps. At his, like, there is no criteria given.
You're suggesting, Dr. Ganesh, that having the representatives of the management association, management of schools, and then having the institutes, that would be like almost like double dipping.
Yes.
That one needs to become redundant then.
Well, what we are saying is that that should not be part of the law. The law should say there shall be a education advisory council, and the rest would be in a regulation. Regulation you can keep changing easily than the law itself. The more you specify in the law, the difficulty would be that a particular minister may try to ignore it, and then, it becomes redundant. Let it be in a regulation. The law should be, there should be a education advisory council which should be representative of various stakeholders.
The flip side of that, the way that you have it here, it's specified who must be in there. If it's all in the regulation, that means they can just change it. What would your comments be on that?
Yes, but the difficulty is that the minister may ignore it, ignore totally the council, and the council becomes redundant in effect. Because later on it says the minister is not bound to accept the advice or recommendation. So we are suggesting that.
Could that then be tempered by requiring the minister to say, if he goes against the advice, to say why he is going against the advice? Okay.
We are saying that wherever a minister doesn't accept the advice or recommendation, he or she inform the council of the reasons and ask the council to relook at the matter so that there is some kind of a agreement between them. Yes, this is in the functions section, section 18. This council deals with advice and recommendation to the minister on any education related matters. Any means up to higher education and PhDs, for example. But the composition of the council is largely to deal with primary, secondary and ECEs. We have got only 2 reps from higher education institution in a big council, which is required to advise on every aspect of education. I think there's a bit of a problem there. That's why we are suggesting that higher education should be part of a separate law. The functions require providing strategic guidance, assisting the minister, and resolving education related issues. Now that is operational. Why do we require the council to resolve issues in schools? Or say if there is a dispute between head teachers and all that, should the council go, or is it Ministry of Education function? So some of these things, the words there, we need to think about very, very clearly. Assist the minister to address and resolve education related issues. Then if you go to 19, it says the council has the power to do all things necessary or convenient. To carry out the functions which are listed there, the council would need people, the researchers, people who take minutes, who implement, the civil servants, in other words. But there is no provision for that in the law on that. It says they can do anything that is convenient or necessary. Does that include hiring people? Because a council without people, with only members, won't be functional. There has to be a secretariat and all that. So there is no provision for that in here. Meetings and all, we are okay with that. But once again, our broader suggestion is that all this should be outside the law. It should be in a regulation, not in the act. Annual reporting, again, an issue that we want to flag. Says each financial year. Now, financial year is defined as July to, I think, June. Government's financial year, I think around that period. But education year, academic year is January to December. So the council, which deals with the education matters, is required to report on the financial year. Now there is an inconsistency in that. The bigger issue we are pointing out is that this whole matter of a budget in middle of the year, following the North American, the temperate budgeting zone, it should be changed. We should go back to January to December financial year, because that's how our business is conducted in Fiji. All schools, year is January to December. Secondary, primary, ECE, tertiary. But government's budget is from mid-year, July or so, to next year. That needs to be dealt with. Otherwise, we will have the council reporting from July to next year, June, while the academic year is January to December. Also, there is an issue here that we want to flag. This report will go to the Parliament. Minister is required to table the report of the council in Parliament. Normally, my understanding is that Parliament deals only with reports which deal with state entities. So Ministry of Education report will go, but this council is not a state entity, it's not a body corporate, so to say. Later on, there is the Teacher Registration Board. That report goes to Parliament, that's okay. It's a body corporate. But this is not a body corporate. So the report of this council should be incorporated in the Education Ministry's report rather than a report direct to the Parliament. It might sound nitpicking, but we thought we will flag it because they will come to create problems later on. Then the major one is the Curriculum Development and Assessment section 5, National Curriculum and Assessment Authority. Now here we are creating an authority, a body corporate, so to say. The question I am posing, is that the intention? The ministry will outsource curriculum and assessment to a statutory authority. If that's the intention, then we can examine the rest of the thing. In other words, what will the ministry's function be? To just appoint the authority members and receive reports, or carry out the operational functions of a Ministry of Education? There are pros and cons. A national authority, statutory body or body corporate to deal with curriculum and assessment is a risky way forward. Curriculum and assessment will be done by an authority while funding will be done by the ministry. So the ministry will have to be required to fund a curriculum which an independent body, a body corporate, will develop, and modes of assessment, etc. So there could be a problem later on. On the curriculum content, if you go to section 3, cultures and customs, we are saying that there are people like Indians in Fiji, no reference to them, Banabans, Chinese. Is it included in local communities? Or should we specify them if we are to specify them? But the bigger issue that we want to point out is our students don't know Fiji's history. There is social science curriculum in school. Primary school is compulsory. But history itself is more than just social science. So there has to be some mention of history of Fiji as a compulsory component of our curriculum, like digital literacy, like health and nutrition, PE, etc. History should be compulsory. It should not be left to a curriculum authority to assume that history is included in the curriculum. Now,
Sorry, Chair. So under that I, you would add history, culture, customs, history,
yes, history of Fiji,
under that I.
either that or J, somewhere. On the membership of the authority, it's specified. Once again, it's led by the Permanent Secretary as Chair, Permanent Secretary for Employment Ministry, Director of the Commission. We presume this commission is the Higher Education Commission. A qualified and experienced assessment specialist, 2 reps from higher education institutions like in the previous one, 2 reps from teacher training institutions. Teacher training institutions, but they're also in the higher education institutions except for the Corpus Christi. So is it duplication? What does it mean? And Fulton, Fulton, teacher training is kind of limited there. It's more technical. So effectively, okay. If you go to 29, this is where the functions are, and we have highlighted this. that authority will implement the national curriculum framework and syllabi and learning standards for all educational levels prescribed by the minister. So it will implement, it's operational. They will actually be required to run Ministry of Education. In effect, what it means is the Ministry of Education will effectively, the major functions will be carried out by the authority. I am not sure whether that's the right way to go.
Can implement also then mean to make sure that the players implement rather than they implement, but make other players implement this curriculum?
Well, then it has to be specified. What does it mean? If you look at further down, D, to design, develop, and administer and manage national examinations. So the authority will be responsible for managing exams, from question paper to administration of the exams, and then assessment. So they will be responsible for assessment of the papers. Not Ministry of Education, it will be the authority. Establish and maintain a system for certification. Provide guidance, resources, and support to schools and educators. So this authority will provide support to educators, teachers, and to schools. Now that's highly operational matter which currently is carried out by Ministry of Education. Collaborate with relevant stakeholders including educators, parents, community groups, etc. Publish and disseminate exam results. So effectively, most of the functions from Ministry of Education are going to the authority. Education Ministry hires teachers, approves schools, carries out, develops curriculum and implements them and assesses. So all the things to do with curriculum and assessment up to exams is left to an authority. And the difficulty with that is there are only, in terms of quorum, 6 people will decide on that. 6 people is the quorum for this authority. So 6 people in Fiji, including, we presume the 2 permanent secretaries and other reps, can decide on every aspect of curriculum, teaching, mode of delivery, assessment, exams. It's a very risky thing, I would suggest. As you say, section 31, if you go down, it says quorum is authority is 6. So do you want to entrust most of the operational part of the core element of Ministry of Education in the hands of 6 people? If I may go further, Chair. Religious instruction, section 34. Religious exam instruction, will it be timetabled? Will it be examinable? How much time can a school devote to religious education? Because that will also compete with the other elements of the curriculum which the school will have to deal with. So that's not specified. We agree with the matter of consent, but we are suggesting that consent should be in writing by the parent, not a general consent on enrollment. Sometimes an enrollment form can say, I hereby consent. By enrolling my child, I consent to religious education. Now, of course, when you are rushing to enroll, you blindly sign. But this consent should be specific consent by the parent. There is one other matter which I want to raise before you say. A student who is a child must not receive religious instruction unless his or parents, they consent. Part 3, a teacher or student must not be compelled to act in any manner that is contrary to his or her religious belief. What about school uniforms? Can a student say, Now, this school uniform, white shirt and brown pants, is contrary to my religious belief. I want to wear turbans and carry a kukri, that small knife. That's my religious belief. Or wear a burqa, hijab. Now, these things will create problems later on. What about school uniforms? Are we moving away from school uniform? In New Zealand, you don't need uniforms. You can go in outings to school. I don't think even in primary there is school uniform. Are we moving towards that side? So we are just raising these issues which emanate from these things. This law is going to become a law. The further down, 37, it says commission to provide careers information services. I presume it's the Higher Education Commission, not the teachers. So Higher Education Commission will have to go and give careers advice. Is that what you want the Higher Education Commission to deal with? That's a question that I want to pose here. Part 6, schools. I have raised the matter of private schools. It needs to be defined. Section 40, if you go down, technical and vocational education and training. TVET goes to diploma, advanced diploma, even a degree. So, would a school be saying, under the law, I can teach TVET, therefore I'm going to issue a degree, bachelor's in TVET, Bachelor of Education in TVET. There is a program, BTech, Kalesh? There is a program already. That's TVET. Advanced diploma is a TVET. Or should you define TVET for schools? What we are suggesting is that there should be a strict definition and limit to where you can teach TVET in schools. And that limit should be up to certificate level 2, on the higher education framework, not beyond that. If we may go further, Division 4, Section 47, free primary education is mandatory. I had raised this matter earlier. Also, there is an issue. If it is a private institution, why should the ministry scrutinize who the manager is? If you are not funding it, what's your business in scrutinizing who the manager is? So some of these things will need to be dealt with. Some grammatical error, a person that intends to, person who, and a person is the natural person and the legal person and all that. So, approval for establishing a school, do you want it in a law or should it be a regulation? Schools need to be approved, but all the criteria, for example, a government-aided school establishing the proposed school would be suitable and reasonable use of public funds. How do you define it in effect? What is reasonable use of public funds? A minister can say, no, I won't approve this school, but I'll approve that one. So these arbitrariness we need to get rid of from a law. If it is in a regulation, then you can amend it but easily than a law.
One way of saying that the word reasonable could then be defined in the regulations themselves, as it what it means.
Yes.
If we have something like this, and it's defined further there.
What does it mean? Yes. On 54, application for certificate of registration or recognition, we are saying that part 2 is redundant really, because once a decision is made to register or recognize, a certificate follows. Why does the school have to apply again for a certificate? You know, approval means you give a certificate. So there should be no requirement on them applying again. 55. Our suggestion 55.2 is that fail to conform to the conditions prescribed. It should not be individual institution based, it should be category based. Like there should be some criteria which should be applicable to all rather than individual school based. If you go further down,
To, rather than for the school or for the category of institutions.
yes,
That's good.
yes. Approving home schools, minister, permanent secretary will approve the home school, but only when there is not enough adequate school in the area. So a person staying in Suva can't have a home school because there are so many schools, primary and secondary. What about, say, where a parent says, I'm not happy with the standard, I want my child to learn all these things. So these things raise serious rights issues. So a person will have to apply to the permanent secretary for approval for home schooling. I don't think there are too many cases in Fiji where there is homeschooling, but there might be some cases in future, particularly with the advancement of technology. We may think that, oh, in primary school, kids, they are better suited for a certain level of technological education, which is not given in the curriculum. So I want to teach them at home. We don't know what will happen in the future. One other general matter which we raise in relation to this is that wherever there is reference to application or apply, there must also be a requirement on response. So if you apply, then the authority must decide and respond within a certain period of time, maybe 5 working days. Not application is made and authorities sit on it for 1 year, 2 years, So there should be a requirement. Wherever applications or apply, the terms come, a response period, which is reasonable. Some more, I guess, drafting issues. 59. Good government of Fiji. I think it should be good governance. There's a difference on that. I think this thing is repeated twice. Good government of Fiji. We are saying it should be governance. Again, stopping home schools, good governance. Okay, appeals. In this particular case, appeals go to the minister. But in certain other situations, for example, teacher registration board and higher education, appeals go to an independent tribunal. Why not here too? See, normally, except for, of course, the current case with the Ministry of Ethiopian Affairs, normally the permanent secretaries are extensions of the minister. So if the permanent secretary has decided on something and you want to appeal, it goes to the minister will decide on the same thing. So it's a bit of a problem. Appeal should go to an independent tribunal. Inspections, section 65. One inspection at least per year. So we will have 900 inspections Fiji-wide. I think there are over 900 schools. So that's a resource matter. Inspections are important. Sometimes actually you might, in the old days there were many inspections. Every term there used to be an inspector coming to the school and head teachers will be running around cleaning everything up. I remember. So inspections are needed, we agree. General must not admit a student after 2 weeks. No school is required to admit a student after 2 weeks from classes. But then you require compulsory education, compulsory attendance. So this is in conflict. If someone is, say, delayed by a boat from somewhere, on islands, coming to give yes, you can't enroll after 2 weeks. So this is too onerous provision. Also, if there is a Fiji citizen staying in another jurisdiction, say North America, where the school ends in May, and they move back to Fiji in June, what happens to that student? Can he or she enroll or remain idle for 6 months?
Chair, if I may, sir. I think there's a provision in there. If you read straight after it, it says, despite that particular subsection 1, the PS can approve the admission of a student for a prescribed reason. So that may be covered under that.
Yes, it may be, yeah, correct. But then you have to apply to PS each time. Why give that trouble? I think the protection is that the student won't miss out on the curriculum. So the education part. But that can be taken care of by the heads of the schools.
Suggesting that it's just discretionary with the school. It should be discretionary with the school.
If you want compulsory education, then you should not have these kind of conditions.
Okay.
There should be administrative mechanisms to deal with this, not a legal mechanism.
So you're suggesting remove this and leave it to the discretion of the headmaster or principal or whatever.
And regulations. There could be regulations. So putting it in a law is a bit of a, for me, uneasy thing. Yeah. Also, the head of the school must not assign or permit a teacher to be in charge of a class more than certain number of students. Later on, there is provision that the minister can prescribe on the student-teacher ratio. I think it's the last section. But what if there is no prescription? What's the class size in Fiji? Is there any guideline? This thing often comes up in reports. So now, if the minister prescribes, say, a teacher-student ratio, say 1 teacher to 30 students or 25 students, then the minister will have to make provision for so many teachers. Funding, appointing at the right time, all these things. One thing which personally I am a bit worried about is zoning. The law prohibits zoning. Now, zoning, I want to suggest to the Honorable Committee, is a way where the standing of a school can be improved. Let me explain what it means. Suppose I stay in, say, Rewanga, and the school in my zone is, say, Vishnudeo Primary, or, generously. And if I am required to send my kid to one of those, I will demand standards to improve. I will have a stake in it to improve the standard of the school. If you don't have zoning, I will send my kid to the best school because I can afford that kind of thing. And then the rest will be left with a school which is not up to that level. Standard in terms of facilities, in terms of furniture, in terms of upkeep, in terms of standard of teachers, training and all. When you have zoning, then parents and all stakeholders have an interest to build that school. So I am personally suggesting that this should be eliminated. If later on some government wants to keep it for a particular time, that's fine, but not in a law. Zoning is a very powerful mechanism of improving the quality of education in the schools. But also where you pay bus fares, the government pays bus fares. It's easier to send children in your zone, cheaper on the state, rather than to send to a distant location. So I'm flagging it for your deliberation on this. Student councillors, yes, councillors are important. Every school must have either a councillor or make provision for a councillor in a private sector or whatever. I'm just flagging the number of councillors, over 900 new posts. Is Fiji ready for that? Or should there be regional councillors? Counselling is important, particularly now with all sorts of problems coming in the schools, behavior, drug-led, substance abuse and all that. Okay, torture. There should be no torture. What if a student claims that any aspect of curriculum causes him or her torture? For example, a part of history which we don't want to hear, is painful. Or physical education, or art. So this torture thing, a bit of a worry for me, mental torture. I guess the intent is that we don't abuse physically. That should be the intent. But we'll have a problem when you put it in a law. Look, I am tortured in the mind because of this part of the curriculum. So, on fees, it's assumed that all fees, the government, whatever money the government gives, is sufficient to upkeep the school. That's the assumption here. Boarding fee. Who prescribes the boarding fee? Prescribed boarding fee. I think there is no provision for that. Should the minister prescribe, or should the operation people who look after boarding prescribe? I know one school in Levuka where the boarding system was ended, and when we talked, casual, said, look, we can't cover the cost from what government gives, so better not to have boarding. That is school on the hill? Dilana, yeah. And it's a reasonable state to take. So the boarding fees should cover the fees. There should be, menu which should be costed, and the money should be given. Of course, they may levy a charge, or charge a levy for number of things approved by the Permanent Secretary. Fundraising. No pressure on a teacher. So what if a teacher refuses to participate in approved fundraising? Can a teacher do that? It's approved fundraising by Permanent Secretary in the school. A teacher says, no pressure on me. My job is only to teach. You will have situations like that coming up once you put these things in a law. Now everyone wants to, well, most people want to become bush lawyers. They read and say, oh, that's my right. See? So, auditing. Every school must have an auditor authorized by the Auditor General. So there will be 900 plus letters to the Auditor General, to approve. It's too cumbersome. It should be anyone who is part of the, there's a body, there's a list of auditors, Yeah, panel, Yeah, approved auditors, they are all, Okay, functions of the board. standards of, see, this is where there is a bit of a problem. This is the Teacher Registration Board, FTRA. No one can teach without registration, correct? But to be registered, you need 1 year's teaching experience. It's in the law. So if you can't teach, how can you be registered? So I'm flagging this to you for your attention. And I've given the details in the thing. Chairman say, teacher registration is an important matter. But the way this thing has evolved from the initial proposal on teacher registration, the board has become only administrative. It has only an administrative function. Receive the qualification document from the potential teacher, see if it is authentic, and give a registration. It's an administrative function of a board. Now, for me, that's kind of too much money into an operational matter. When the teacher registration board was initially proposed, it was modeled on the same lines as the legal, the legal registration, the accountants, where one part of continuing registration was continuing education, professional development. You had to participate in so many hours of learning outside the job. Though that part is missing totally. Though in somewhere it says that you have to specify what have you gone through in the last 12 months, but it's not part of the registration requirement. So that this particular body corporate is only to receive applications and compare it with the requirements and approve. And normally body corporate is paid better than the civil service. So we'll have a category, and there will be, issues later on between civil service and the board employees.
Are you suggesting that the functions of the FTRA should be amended to include that compulsory personal development
Yes.
functions, and that they monitor that?
Precisely. That was the original intent, that you will be given initial registration, but every 3 years, when renewal comes, you have to show so many hours of professional development. And this could be in the form of attending, refresher courses, conferences, writing papers, number of indicators could be used, like the lawyers and the accountants. So that was the whole function of a registration board, so that professional standards improve of teachers, especially now with technology coming up. How many, AI, even basic typing and Excel skills are important. Now, if you want to have AI, you need to have data entry, all these skills which may not have been taught 10 years ago, but they are still teachers. So there has to be professional development. Continuing education, yes. Yes, so I have elaborated on this in detail, that the law requires 1 year of teaching experience to enable a person to register. But you can't teach without registration. So it's an anomaly there. There is one other bigger matter. I'm coming towards the main gist of our interest. There is a difference between teaching and training. Teaching is from books in the classroom. Training is different. Training is practical. Everywhere we are referring to teaching and all that. There is no training. TVET deals with training. So what we are saying is that this law pays only lip service to TVET. It has mentioned it here, there, but it's not serious. Because if it were, then it will define training. And then the teacher registration board, there will be a different criteria. You need to have different qualifications. So teaching carpentry, you need to have a certificate 3 in carpentry, and training of trainers, or some relevant teacher. You don't need to have a bachelor's in education to teach carpentry. There are specific training programs. See?
Dr. Ganesh, just on that, what is the current practice now?
Current practice is anyone who gets any qualification, teacher training, is registered. And the teacher training qualification is the industrial arts, what was the industrial arts and home economics. So that's why the schools are suffering from TVET, because they can't employ a skilled or competent hands-on person, because that person doesn't have a diploma or a degree in teacher training. While
So there's a deficiency in terms of industrial arts and home economics teachers.
yeah, very true. Very true. Huh? It's a big problem in schools. It was a big problem, earlier. Schools had difficulties getting skilled, competent trainers. Because they are not teachers, they are trainers. So there is a distinction between teachers and trainers.
And this mostly happens in vocational schools that also do vocational studies, correct?
Yes.
And it is your suggestion that those that come in to teach these vocational studies have a certain training, a certificate, like what you said, to level 3.
Yeah.
So for example, we have RKS, who's a vocational school. So for those who want to teach vocational studies there, whether it be engineering, carpentry, joinery, them to have at least certificate 3 level. Is that correct?
Yes.
Okay,
They don't need to have a Bachelor of Education.
right.
So now also it has to be built into the salary structures and the entire, the paperwork that is required.
Right.
At the moment,
So previously, like the schools had industrial training and also home economics. What was the qualification needed for teachers then that were teaching those two particular subjects?
a diploma in industrial arts or a diploma in home economics. But we have moved away from diplomas. Now we are all focusing on bachelors. Now once you get into the bachelor level qualification, your hands-on experience comes down. So you have teachers in schools who have the qualifications but who don't know how to operate a lathe. There's a whole range of technical things. That's why TVET is suffering. I'll give an example. Now, ministry has been trying to push TVET back in the schools. I think 36 schools were identified. Of that, only I think 6 have been so far registered with the Higher Education Commission to teach TVET up to certificate 2. Yeah, level 2. In fact, there are some sections in ministry which are trying to push it to level 3. In some schools, but it's not happening because of one of the problem is trainers, competent trainers. Then of course there are other regulations which guide OHS and all these things. So out of the 36 listed, only 6 so far have been registered. 1 year or 2 years now. So the ministry is struggling with that. So the better approach is to have a separate, we have an Education Act, but a separate set of regulations for TVET. In fact, the bigger proposal that we are making is in line with the submission from the Fiji Employers Federation on a pathway. After Form 4, year 10, there should be a pathway, higher education or technical education. That is the way to go. At the moment, there is no reference to that. We are saying we go back to the proposal from the Employers Federation and try to implement it in here. That will take care of the TVET and the skills matter. You can't push it in the school system beyond level 2. Beyond level 2 you can't. It's important for people to know how to cut timber and how to nail, students. Even if they are going to become doctors or lawyers or engineers, basic ones. But not beyond that, you see, because it requires certain other skills to be in the system. Okay.
Problem is that they're trying to regard TVET is just like you treat normal education.
Yeah.
Normal education, you know it, you qualify. But TVET, you have to be able to show that you can do it.
Do it.
Which requires somebody who has done it before to teach. And a lot of those people don't have the degrees, which then allows them to be recognized as teachers.
Yes.
So I think that's, as you mentioned, it's a big problem.
Yeah, true. So entire bill is about teaching, not TVET. Though TVET is mentioned. So, if I may, so section 96 reinforces what I have been saying, about registration and the conditions for registration. Also on good character. What is good character? So someone has to be satisfied that a person does not satisfy a standard of behavior generally expected of a teacher, is otherwise disgraceful or improper. Is it the hairstyle, the dressing? What is it? So, you may recall some of your best teachers may have been people who may have funny hairstyles. Remember Peace Corps in those days? Some of them were the very good teachers, but their, character, so-called, was out of the norm. So some of these things. So now, of course, alternative lifestyle. So provisional registration is there. That's a pathway. New graduate will get provisional registration, then you go teach 1 year, and then you get full registration. That might be the pathway, but it's not in this law. Renewal, remember professional development we talked about. Okay, this other administrative matter. At the moment, there are about 500 to 600 teacher trainees in Fiji, maybe even more, primary school and secondary. For them, teaching practice is required as part of the curriculum, but they can't go and do practice without approval from permanent secretary, I think, or some authority. So every teacher trainee will have to be approved by the ministry. At the moment, I recall I was once an assessor, only a category was approved. USP, these students will go to schools. But now individuals will have to be approved. So it's too much paperwork. If I may continue, Chair. Inquiry and all those, we don't have too many comments on that. Okay. The role of teachers. Should it not be made public online? At the moment, it says the role will be kept at the board's office, teacher registration board, and the office, and persons will have to go there during office hours to access it. Why not make it available online? Well, there are other areas where there are difficulties. I think legal is the one where it's all online, but if you try to get a list of medical doctor, it's not online. It's a big problem. Dental, you want to check whether this person is registered. You can't. You have to go to medical office, medical registrar's office and all that. So, higher education, this is where we have a lot of issues. The whole move to repeal Higher Education Act and bring the sections into Education Act, I think is problematic. We are saying that it is already a handful for the minister and the office, the ministry, to deal with ECE, primary and secondary. So far, what has happened is that higher education has been treated as a matter, not the mainstream. Current minister and previous ministers, their main focus has been on primary and secondary. Some time back, there was not even a desk in the ministry dealing with higher education. I know this very well because Higher Education Commission was set up through my own recommendations when we established University of Fiji. There was no office in the Ministry of Education to deal with that. They didn't know what to do. I remember at that time the Attorney General, Mr. Bale, very, funny man. He would always tell me, Ganesh, I'm going to come and close the university in Lotoka. I said, say, please do that. But he couldn't because there was no provision, there was no desk. So the Higher Education Commission was established out of that. And it is an important function. I don't think we should bring it into the Education Act. I know in New Zealand it is there, but in New Zealand also there is a problem. There are two ministers. One is the Minister for Education, one is the Minister for Higher Education. Now, who will report to who is a bit of a dilemma. The way around it is that Higher Education Act remains standalone, and the reporting will be to minister responsible for higher education. The current FNU saga is a very good example of why these things should be specified more clearly. If the law says that that particular institutions will report to the minister responsible for higher education, then the problem would have been solved. PM could have said, look, this is the minister responsible, Minister for Strategic Planning, which is me, no problem. So we need to relook at the Higher Education Act itself, but by bringing sections of it here and repealing the act, I don't think is the way to go. If I may go outside the terms of the submission, perhaps it's time that in Fiji we have a separate ministry for skill development, higher education, science, technology, innovation. These are the in things. We can't leave it to Ministry of Education, which is overburdened with the operational requirements of primary, secondary, and early childhood education. There should be a separate focus, accountabilities. So this is a problem that I am raising. I don't know whether, in fact, I don't even think that many educational institutions are aware that Higher Education Act is going to go. In fact, we were not even aware until we read it. So this is not the appropriate way to deal with it. There should be a notice that we are planning to repeal Higher Education Act, and submissions should be called on that specific matter. The commission continues to exist, but the act is repealed. Now the greater problem is this. In here, we have membership. 129.3. 129.3. Okay. So membership of the commission is specified. And these requirements, they have significantly watered down the standing of the commission. This commission, say, will deal with, say, USP. So it will deal with the Vice Chancellor of USP and the senior managers. It will deal with FNU, deal with University of Fiji, and it will deal with Monash University, all the very seasoned administrators, academic administrators. So the commission member should be competent to deal with that at that level. The requirements here are too weak at the moment. Until recently, until I think last month, we had a chairperson of the commission who had no qualification, and he could never deal with any vice chancellor or serious people in the universities. So all his focus was on smaller training institutions, where he could go and boss around, but never deal with the bigger ones, which consume the largest part of training budget. So the commission members must be at that level of competence. And that competency should be at that, it must specify that you must have certain requirements, which is present in the existing law. So just by being a lecturer, you can't be our submission, you shouldn't be a member of the commission, because they just go and teach. There must be a much more stringent requirement to be on the commission. But also there is a serious problem. If it comes to a review of Higher Education Act, we will bring it there. There is a commission and there is the management, the director. The director is nothing more than bureaucrat in the present arrangement. It's the commission which makes the decision. Commission signs, commission, is responsible. So it's a hybrid between, say, a commission as specified in the Constitution, certain powers of a commission, powers of appointment, powers of termination and all that, while the director is really a bureaucrat. We need to think about that. Director is the person implementing policy. So that is something which we need to talk about. We need to develop so that Fiji becomes an attractive place for foreign students as well. Now with all the rules and regulations in Australia and New Zealand, this is a market. We need credible institutions to tap into that market. So we have got a major issue with that. There is also a problem here on what is a university. 139. Under the current arrangements, you can't operate a university without an act of parliament. You need an act of parliament. PNG has just approved an act to establish the IBS, International Business School University, just last month, last week. So you need an act of parliament. But here in this draft bill, the Higher Education Commission can say you go operate a university. And then subsequently go to the parliament. It says subsequently, well, they have to cause a bill to be tabled in the parliament. What if the parliament rejects the bill and you have already started the university? It's going to create a problem. Also, there are serious issues on registration and recognition and all that. Under the system, you need to employ all your teachers, build your facilities, hire the tools, equipment, buy them, and then apply for registration. What if the application stays for 2 years, as was the case at Polytech? We applied in March 2021. There was no decision until December 2022, almost 2 years. You have to pay all the rent and you have to spend the money, pay the salaries, and you can't operate. It's a big problem. So that has to be streamlined. That's why it's very important the response rate. If you apply, there must be a decision within certain time. Or if you don't want to have that, then don't have those strict requirements of resource use. Section 141. I remember when Polytech had applied, one box to be ticked was audited financial statements for past 3 years. We said, no, we are just new. No, it's a requirement, you have to submit. And they won't budge. It's a requirement, you have to submit. These are the kind of things that can become hurdles. I've talked about the investee matter. An investee can operate, and then the bill goes. The question is, what if the bill is rejected? That's in section 143, 142 and 143. Okay, accreditation of programs. So, section 148. The minister must prescribe the process for assessing applications for accreditation of courses and programs in investees or degree awarding institutes of technology. If you have a commission, then why the minister? The minister, generally speaking, a minister is not competent on programs, and accreditation, the standards. That should be the function of a commission.
More reason for your separate thing altogether.
Yes. A commission which is competent. Not only a commission in name, but a competent commission. On appeals, section 150. This is a good provision. There must be appeal provision. The person should be competent to serve as a judge. But we are saying that this is educational institution. It should also include competent to be, say, a vice chancellor. That level. So not only legal, but also educational skills. But the problem is the appeals are restricted to matters of registration only, not on other operational matters. Where do you go and appeal on other matters? For example, if some institution is doing things which are contrary to the law or the regulation, where do you lodge a complaint? There is nowhere. You can lodge a complaint with the commission, and if the commission doesn't do anything, where do you appeal? There is no appeal provision. And a lot of funny things are happening in higher education sector, let me tell you, say, with all due respect. We deal with it every day, but we don't know where to go to. Irregularities and all. And it's affecting the standards of graduates that we are producing in Fiji. Also, financial year, 1st August to 31st July, section 153. So, Higher Education Commission's financial year is 1st August to 31 July, but they deal with academic year, which is January to December. Inconsistency. Miscellaneous, section 159. Commission may require higher educational institutions to submit any information they want, any information, not only those relating to the programs that they are offering. So, for example, they will demand, whom are you negotiating something with? These are commercial in confidence matters. For example, if you are buying a property. Now, we have gone through that, the problem. We bought Nandi College, and there were other competing parties, and fortunately, there was no demand for the, commercial discussions with the owners. But under this, commission can demand that. And especially if you have a rogue commission, which is favoring another institution, then there could be a problem. Your confidential information will go to into the hands of others. It should be limited to the functions. General powers. This is General Powers Overall Education Act. There has to be general powers of the minister. We have no problem with that. There are penalties. There are miscellaneous. The Act must 174 Act must be reviewed every 5 years. Not practical. My own experience, not practical. Even the Law Reform Commission members, you would know, you are lawyers, it's not at the rate that we would want it to be. So why do you have provision which you can't really enforce? All the prescriptions are there. I bring your attention to section M, subsection M of 175. Prescribing procedures, requirements, and other matters related to technical and vocational education and training. So minister can take out a regulation. But is that sufficient? Who will, minister takes out a regulation, who will be the implementing agency? Would it be Ministry of Education? Would it be the that authority, the curriculum authority? Would it be the Higher Education Commission? So there are all these difficulties which are there. Certain acts are repealed. Subsidiary legislation under those acts are also revoked. But there is continuity and there is provision for continuity. We have no problem with that. Our major concerns are 6 of them. Let me go through that. They are listed in section 176, subsection 2. Yes, if you click there, we've got 6 issues we want to place before you. Say these are not necessarily in any order. Number 1, the authority. The content is like creating a body corporate, but all the functions are body corporate, except it is not a body corporate.
You talk
That
about
assessment, the curriculum.
the curriculum.
Yeah,
Okay.
authority. I think the idea would have been to create something like the Fiji Teachers Registration Board, but they haven't gone to that extent. So this needs to be re-looked at. The functions are like a body corporate, but they are not empowered to act like a body corporate. TVET is mentioned in passing only. There is no definition even. Higher education must be dealt with separately under Higher Education Commission. TVET and higher education are regulated globally through what's called a qualifications framework. Honorable Sumatya knows about this. But there is no reference, no mention of it at all in this. We are required to do TVET in schools, but there is no reference to the qualifications framework. So we need to deal with that.
So from your experience, is the National Qualifications Framework still being used in the sector in Fiji, or is it,
Well,
what's happened to it?
thank you for that question. It's there on paper, but it's not effectively monitored. In fact, it has been ignored totally and watered down. When you look at the the framework is, Chairman, pardon me, is level 1 to up to 10. 10 is PhD, level 1 is the basic, and each has a certain requirements, competencies, outcomes. If you look at what is there now, it's far different from what was there when we were developing it in the early days. And I can understand why, because the commission members are not competent to deal with it. So they have watered it down totally. So now you can have, if I may, this is not confidential, it is public, it could be public information. You can have a certificate 3 with 450 hours of learning. Huh? Now, for me, that's thoroughly insufficient. You can't create skills in 2 terms, 20 weeks. In 20 weeks, you can't create the competencies required at certificate level 3. But most of our qualifications from Higher Education Commission are like those. That's why employers are complaining that graduates don't have the competencies. And we as providers, we have to follow the requirements. So we are in a dilemma. And there are providers which benefit from this. They take full advantage of it. So if you see advertisements, they'll say, you get a certificate 3 in 4 weeks, 8 weeks. Now, this is...
Certificate 3 is a fully fledged tradesperson. That means he can do it all. That's what it means. Eh?
And you can't do that practical within, 20 weeks. It's just impossible. Ours is 1 year, 40 weeks. 40 weeks of full-time study. And, learning and practical. So you need to have reference to the qualifications framework. It's a very useful tool. It's done in all jurisdictions, Europe, Australia, US, everywhere. Eh? We can't ignore it. So when you talk about TVET, there must be reference to the qualifications framework. That's why we have been suggesting that in schools, the maximum should be levels 1 and 2, basic, and up to a certain level. Certificate 3 is different. Also, there is no pathway. I had earlier mentioned that there should be a pathway. And the pathway, if I may suggest, should be from after Form 4. Up to Form 4, Year 10, basic, all the education, everyone does the same. After that, we should have the opportunity to channel students in different pathways. The idea of technical colleges was a good idea. I think that was the way to go in Fiji. It was, I think, under Fiji Fest time. But I think what happened is that they messed it up in implementing. They rushed too much.
Just to clarify, I'm no longer in Fiji First now.
Thank you. So, I like the idea, but it was implementation which was messed up, and therefore no more pathways. So any student, we are dealing with the students, they don't want to do Form 5, commercial studies, or Form 5 geography or science. They want to do technical, but they have to go to the school to do it. There is no pathway for them. This is the time to review this. We need to provide in the law that opportunity for a pathway. And fortunately, this provision, this suggestion was also made by the Employers Federation in their submission. I have read that this morning again. It's very strongly coming out. So if the employers are saying that this is the way, I think we should heed their advice and at least consider it before we reject it. The final matter that I want to raise has to do with student health. There is no mention of student health in this bill other than for the dental checks, those medical checks. That's not good enough. I think there has to be provision on student nourishment. And if I may suggest, as policy, not as part of the Act, 1 meal a day for primary school. Full meal, not only with bix and milk, eh? Full meal, healthy meal. But in the law, we can say that one function of the minister is to ensure that all students are well nourished. Now, how he does it is part of the regulation. Japanese, yeah. It's not easy to implement in a new environment, but it is possible. Even India, India has a meal a day in schools. Tens of millions of students. Huh? There are also problems, mixing and all that. But if they can do it, why can't we? And I think our systems are more attuned to providing that meal, at least one meal. So, Chairman and members, thank you very much for bearing with us. Our suggestion is that this bill must go to the drawing board. Relook at it thoroughly, every aspect, and then bring it forward. Not because we need to review and we review and create something. Thank you very much.
Thank you very much, Dr. Ganesh, for your presentation. Any comments or questions, honorable members? Okay. I just have two. First one is on compulsory education. What are your views, or what is the view of Pacific Polytech on teachers, on parents being held criminally liable if the students are not going to school? What are your thoughts on that? As an educator.
Yes, thank you. I don't think that should be part of the law of the Act. It should be part of other processes, regulations, and operational thing, guiding the parents, counseling them, advising them. I stay in Rewanga when I'm in Suva, and I see school-age children running around in that area, collecting uto and coconuts and all the school-age children. I talk to them. Oh, I just didn't feel like. Your parents, oh, they are away, So you can't put them to jail or fine them $2,000, I think, or 20, whatever it is. No, that's not the way to go. I think there has to be another intervention mechanism. And that mechanism should not be prescribed in the law.
Naka. Thank you, Dr. Ganesh. My second question is, with respect, what would your thoughts be on establishing an education tribunal within the law? I understand we have the Tribunal for Higher Education Commission. My question is on, if you look at the bill itself, there doesn't seem to be any clear appeals mechanism on other matters. With respect to employment of teachers, we've got the employment tribunal. That's fine, they can go there. However, other matters, what are your thoughts on putting something to deal respectively to education? Education is so big, there's so many matters. And the only restitution that people get, if you look at the bill, it's at the direct, you can appeal to the minister, but it's a political decision. Other than that, then it's straight to court, to try and give some relief to other areas where people or even institutions or even some anybody needs to find some restitution. There should be an appeals mechanism in place. What are your thoughts on that?
Yes, thank you, sir. Yes, I agree. You may recall that particular case from Vanuatu, that school which was deregistered some time back. Yeah, it shouldn't have happened. If there was a tribunal like that, it could have dealt with it. So there has to be an appeal to our independent body, not to the minister. I think that's the way to go. But also the scope should be appeal on any aspect which are not administratively doable, like after the decisions are made. Even the Higher Education Commission is very restricted in terms of appeal. So there is a need for that. Thank you.
Thank you. Also, sorry, Honorable Sumate has question.
So along those lines, you suggested the separation of higher education from this. So then would that mean that under the higher education there is a tribunal, but it's limited currently to whether you are approved or not approved? You would broaden the scope of that,
Yes, precisely.
Okay. Okay, the other thing, since we have a distinguished rugby player amongst your group here, what do you think of in the options coming up after year 10 to put rugby as an option for people that want to go down that path?
Chair, I think what we've done now is that we've been in touch with Fiji Rugby Union, ensure that there is always a life after rugby. So conferences are in progress now, and we ensure that we will meet with them in 2 weeks' time.
I'm asking if people want to have a separate subject of rugby in year 11, rather than, for them to actually start rugby. So you have a rugby as a subject.
Yes,
after
that's,
year 11?
Chair, yes, that's possible, Honorable Usmati. You can put rugby as a separate subject after year 11. Nak.
Year 10, yes.
Year 10.
Thank you. I also agree with that. There is a need for it. I'll give a case. Not only rugby, there is a lot of money in golf. So I know for a student, this student and my son, they play golf together. And his parents arranged the son to be trained in New Zealand for 6 weeks. And the fellow went, came back, and he's an A-grade player now. But he left school for that period. If there was this pathway, then there will be no problem. So there has to be pathway for alternative income earning opportunities.
Thank you. Honorable Dr. Ganesh, what Honorable Usmati was asking, this was a submission that we received while we were doing consultation, because the justification was rugby is now a source of income. It's bringing remittances to the country. It's contributing to the economy, rather than being it as an extracurricular activity, which we in our education system, sports is just an extracurricular activity. And that was the submission that we wanted to hear from you. But anyway, are there any more questions, honorable members?
Honorable
No.
Chair,
Oh, yes.
it's a matter of clarification for the public out there. This regarding interested in Tibet. For those experienced carpenters out there, they don't have certificate. What about if they want to come and grant with certificate? They'll still going through the 40 weeks, or? That's my question, Doctor.
Thank you. Thank you very much. There is on the provisions now what is called recognition of prior learning and recognition of competencies. So we, providers, including Pacific Polytech, if there is a person, we will assess his or her competencies and only do the fill up. You don't have to spend 40 weeks. So once we assess what competencies the person has, what competencies the person needs to get a certificate, just fill up those. Normally, people who are out there in the field, they have got the practical experience. The shortcoming is in the theoretical side. For example, how to do calculation, how to access information. Now, most of the information is available online. How to access that, how to make sense of it, those kind of things. So there is provision. We have got them in our policy already. We tried it with one particular institution, but then there was no funding for it. So the people dropped out. Like there has to be someone who will pay for it. And TELS is not geared towards that. It's geared to a full scholarship. So all these reforms are needed. Thank you.
The other system that is there also is that for the national trade test. That was under FNU, but that needs then to feed in to be recognized as part of a formal qualification. So that pathway needs to be there.
Very true. So all these things are, there's a lot of things which needs to be reviewed, and we are saying that it can't be done by Ministry of Education. It's something separate. There has to be a separate mechanism, and if I may propose, a separate accountability and ministry to deal with skills, innovation, technology. For me, it's very worrying. Number of patents we have registered, Fiji. You can count them maybe 2, 3, 5, I don't know. We have been having investees here for so many years. What's happening? There is a National Research Act, you may recall, passed in 2017. Fiji National Research Council Act, this is a legislation, but it's not functioning. It comes under Ministry of Education. It's not functioning because it's something outside the primary, secondary school mode. Now, small countries have innovation. They register patents. They develop new technologies, particularly now with traditional knowledge. It's coming very handy in climate change, coming very handy in, say, food products. What we consumed is now being used as mainstream, and people are patenting these things, cover, for example. So there is a need for a special focus on research, innovation, development, science, technology, higher education, TVET, skill development.
Thank you. Thank you very much, Dr. Ganesh. Honorable members, if there are no other questions or comments, I believe that's us. Well, we thank Dr. Ganesh and your team from the Pacific Polytech this afternoon. We started in the morning, now it's afternoon. Thank you very much for that comprehensive submission on the education bill. The committee takes note of your submissions, and we will surely deliberate on the things that you have highlighted and flagged for the committee to look into. Other than that, honorable members and our submittees this afternoon, and ladies and gentlemen who are tuning in live, that concludes the public submission this afternoon. We thank you very much for your attendance. Pinabaliw.